For this episode of Scholar Talks, the guiding question is the Supreme Court the final word on the meaning of the Constitution? So our guest, George Thomas, is the Bernadette C. Wofford Professor of American Political Institutions at Claremont McKenna College, where he teaches constitutional law and American political thought. And he's the author of the Madisonian Constitution, which is the subject of today's discussion. I am Tony Williams, Senior Fellow at the Bill of Rights Institute, and I want to welcome you to another episode of Scholar Talks in the America 250 series. George, I want to thank you very much for joining us.
Well, thanks so much for having me.
Sure. I really love the book. Some great, a great examination of the American Constitution as Madison originally intended it, the relationship of the separation of powers and how each branch interprets the Constitution, as well as some really great case studies to illustrate the points you make. So we'll start with a big question, but in a nutshell, what is the Madisonian Constitution, and why is it relevant to the understanding of judicial review?
Okay, well, first, thank you so much for the praise of the book and for having me. It's a delight, especially first book. It's been a little bit since I've written for people to rediscover it, I suppose. So maybe the easiest way to start in thinking about the Madisonian Constitution is to really take conventional wisdom, and conventional wisdom that's probably dominant, certainly among the political class and most representatives, and has been for half a century, maybe more. And that's that when we think of the Constitution, we think of it as fundamental law, but fundamental law like ordinary law, and that the primary mechanism of enforcement is the courts. And so judicial review, in that understanding, really becomes the central way of enforcing the Constitution, and the court then is seen to be the final and authoritative interpreter of constitutional meaning. So to start from a Madisonian perspective, which I think Madison is sort of the central and key figure in fully articulating this view, but as we'll get to, I think it's been picked up by an awful lot of political thinkers over the years, and was, I think, probably pervasive among many leading political actors, political thinkers from the founding generation. And the first place to start really is to think of the Constitution in much more political terms, and to start with the separate institutions, the notion of separated powers. And the separation of powers is not really just about checks and balances. It is about checks and balances, but it's first about constituting these institutions in a manner that they can then best carry out their constitutional duties and responsibilities. And so, for instance, you have a divided Congress, not just to make things difficult. It does make it more difficult, but you want really serious representation among a wide swath of the population that's more immediately connected to them in the House, say. But in the Senate, you have longer terms, you get a voice from the states, and it's these different institutions are going to bring out different versions of representation and popular government, different interests, but they're going to then be forced to think and deliberate and construct good public policy. And that's what you want from a legislature. And in the same way, right, you have a court that is somewhat independent, very independent, and it's carrying out its responsibilities in deciding cases. And then you have an executive, singular executive, who not just administers the law, but can act quickly and decisively in particular instances. But the Madisonian point then is that these institutions are structured in a way that require them, in carrying out constitutional duties and responsibilities, to also discern and think about constitutional meaning in that process. And so the way that's, I think, different than how we ordinarily conceive the Constitution is we should expect Congress to be thinking about the Constitution. We should expect the president to be thinking about the Constitution. And in the Madisonian scenario, no one institution is given responsibility for finally interpreting the Constitution. There's a real skepticism from the Madisonian perspective of reposing trust in any one particular branch and saying, okay, you're the kind of constitutional branch of government. The result of that is that constitutional interpretation is often going to involve some conflict over constitutional meaning. The branches could have different understandings or readings at different times, but that's an ordinary feature for Madison of constitutional government. And that means that we should be more ready, inclined to accept some kind of constitutional conflict and know we're going to have some debates over constitutional meaning, and that they're likely to be worked out as part of the overall political process over time. So very quickly, just in contrast to judicial supremacy, the idea would be that, well, the court decides and now all the branches have to follow what the court said about the Constitution, not just the case before it. From the Madisonian view, there's real skepticism of that. And judicial review still plays an important part in the constitutional scheme. The court hears cases and it decides cases, and the parties to the cases go before it and often have constitutional questions that they're engaging. And so the court resolves those constitutional questions, and those decisions are binding on the parties to the case. That's judicial review, right? Judicial review might find that there's an act of Congress that's unconstitutional or an act of the executive that's unconstitutional. The Madisonian framework accepts that. But in the process of deciding that particular case, the court also renders a judgment on what does the Constitution mean that refines that. And then the question is, okay, so when you go back to the executive carrying out his or her duties, or members of Congress deliberating on constitutional issues, are they bound by that understanding that the court handed down, or can they read the Constitution on their own and say, well, we think the court got it wrong in this case, and so in terms of the broad constitutional question, and so we're going to follow our own understanding of the Constitution. And the Madisonian framework invites the branches to do that.
Great. Thank you. I mean, that's really nicely laid out. And, it strikes me as pretty funny that it seems novel that we would have each branch of the government interpreting and following the Constitution. I guess that's where we are with, the idea of judicial supremacy, as you mentioned. So,
looking at right, as if somehow like Congress is not supposed to look at the Constitution when they're deciding, these legislative questions or thinking about their power, right? They're supposed to just turn to Supreme Court opinions, not the Constitution, right. which is a little bit odd.
Right. So, okay, so jumping into your case studies to really illustrate these points, which I think is a great part of the book. So after the Civil War, you show that Congress and the court struggled over the meaning of especially the 14th Amendment. So what was the nature of that struggle between these branches?
Yeah, I mean, start with just in thinking about the history, the fact that you have the Republican Congress at the time, after the Civil War, forging the 14th Amendment and amending the Constitution, and in part at least amending the Constitution to really kind of settle some constitutional questions that had been disputed prior to the Civil War. I mean, just take one really clear instance of it that you get by a Supreme Court opinion in the years just before the Civil War. That's the infamous Dred Scott case, which says that blacks, free or slaves, can't be citizens of the United States. It also, reads the rights of citizens far more narrowly. And so the Reconstruction Congress wants to solidify its understanding in the kind of Lincolnian Republican understanding of the Constitution by way of constitutional amendment. And that not only makes blacks, of course, there's obviously the abolition of slavery in the 13th Amendment, but then you make blacks or all persons born in the United States citizens of the United States, and you entitle those citizens to the privileges or immunities of citizenship. You command that states respect their rights by way of due process clause, and guarantee equal protection by way of the 14th Amendment. And I mean, just one of the things that's interesting, I think, for especially, people who don't have a lot of background in constitutional history to look at, is when you go back to the Reconstruction Congress and after, you have this, these extraordinary political actors and thinking engaged in these great constitutional debates. I mean, they're incredibly smart constitutional debates. They're thinking deeply about constitutional questions. And we tend to think, as you said earlier, right, that like, oh, well, Congress thinking about the Constitution seems sort of novel. And yet, the debates from that era and the engagement with the constitutional questions are really profound. But so the court, in a series of decisions over the course of the latter half of the 19th century, really sort of narrows the meaning of the 14th Amendment. It does so by really reading out of the Constitution the Privileges or Immunities Clause. And so when you think of, we view the Constitution through the lens of the court, and so we tend actually not to talk much about the privileges or immunities of citizenship. And yet that was really key to the Reconstruction Congress. And it was maybe one of the most important features of the 14th Amendment. And so that period for me is just interesting because you have, to maybe simplify things, but you have a really interesting dynamic of the Congress attempting to enforce the 14th Amendment. And incidentally, the amendment gives Congress the power in Section 5 of it to enforce the terms of the amendment. And so you see right there that they don't want to just trust in the courts to say, okay, we've now amended the Constitution. The courts will tell us what this means. Congress says, no, we're actually going to have an active part in enforcing the terms of this amendment. And as they do so, the court really narrowly reads the terms of the amendment, sort of culminating, for listeners that will be more familiar with it, in the case of Plessy v. Ferguson, where the court said, hey, separate facilities and racial segregation are okay. They're part of equal protection, almost certainly at odds with a lot of the understandings articulated by the Reconstruction Congress that, framed and ratified the 14th Amendment, and those understandings immediately after. So it's a great example also of seeing Congress actively engaged in protecting constitutional rights in a robust way, when we tend to think, oh, well, legislatures don't care about rights, courts do. And our history is just a lot more complex than that.
Right. No, yeah, there's so much to dig around in, but we'll move forward. So a few years after that, a few decades, how did the progressives seek to change American constitutionalism, and did the courts agree in that case?
Yeah, so the progressives, in ways, and especially in the most visible figure of Woodrow Wilson, but hardly just Wilson, the progressives really were skeptical of the separation of powers. And so if we think of sort of the key features of the Madisonian Constitution, it's really rooted in this idea of the political dynamic of the separation of powers, which reflects for Madison a popular government. The idea is that the government it's deeply, small r Republican and popular, and should ultimately be responsible to the people. And yet there's also a kind of skepticism of the people, in the same way that there's a skepticism that any one institution should be the enforcer of the Constitution, because the people too can be ignorant, they can be misled, they can simply not have enough time to consider things. So part of the job of the separation of powers and representative institutions in terms of Madisonian design is to, in fact, both articulate popular understandings, but also to educate and correct those understandings at times, to force a kind of deliberation. And progressives are deeply skeptical of the separation of powers in so far as it often thwarts what they understand as popular mandates. It makes government somewhat more complex because you're elected, but then you can't immediately kind of act on why you think you were elected, because the a progressive understanding sort of introduced this idea of that those representatives who are elected have a mandate from the people. And so they should be able to act on that quickly, and the separation of powers in a more antagonistic kind of Madisonian sense thwarts that, or potentially thwarts. And so the progressives prefer, I think, an understanding of popular government that's far more in accord with something like direct democracy, channeled through especially a presidency, a kind of plebiscitary presidency in ways. And so Wilson and others are trying to think about ways to use both, especially the presidency and political parties, to overcome what they view as the defects of separation of powers and checks and balances. The court at the time is more skeptical of this popular understanding that just because the people, passed legislation or wanted legislation doesn't necessarily mean it's constitutional. And, again, I don't want to get too involved in the complexity. I mean, there are all kinds of questions. Was the court acting outside the bounds of the Constitution? Was it narrowing federal power in ways? I mean, those are all, I think, really interesting and fascinating questions. But in the end, right, I mean, you get this, I think the two things that are interesting to pull out briefly are the progressive kind of skepticism of separation of powers, but it's also interesting because they at the same time are kind of championing that the other branches of government should be actively involved in constitutional interpretation, potentially against the courts. I mean, Teddy Roosevelt is especially insistent on that point. And you end up, even with some skepticism of the Madisonian system, you end up with a pretty Madisonian dynamic between the court and the branches of government, where the court kind of forces the other branches to articulate their constitutional understandings and vision. And you get a bit of that, especially from a William Howard Taft and a Teddy Roosevelt.
Yeah, and it seemed like you're honing in also on the arguments of Roosevelt, of Wilson, thinking that the court's sort of impeding the creation of this regulatory state. That these, if you just put the Constitution sort of in the presidency, as you said, and especially in sort of the experts in the administrative state, that they could sort of create this sort of perfect social order of efficiency and order, and everything would be more harmonious.
Yeah, and FDR really draws on that understanding. In fact, I mean, FDR is a really interesting figure because, on the one hand, he seems to embrace very much, Madisonian understandings, where as president, he thinks the court is reading national power too narrowly. He's skeptical of their understandings. And so he wants to challenge the court and the court's seeming monopoly on constitutional interpretation. And he has these great lines like, the Americans should read the Constitution like they should read the Bible. It should be something that every citizen knows. And that part of it, I think, is deeply Madisonian. And this idea of engagement with the Constitution, not just among the people, but by the Congress and the presidency. At the same time, he has these lines where in his famous court packing plan, or what becomes known as the court packing plan, he of course didn't call it that, but he has these lines where he wants to say the separation of powers is this 3-horse team all plowing for the people, and the court's sort of leading us astray over here, and it needs to get in line and plow. And that very much represents more the sort of progressive vision you're talking about, that it's like, okay, the government is going to be unified around a particular political party or understanding, and all the 3 branches should then move in lockstep, which is, I think very much at odds with the Madisonian dynamic, because you're trying to bring one branch on and say, okay, you now go along with us. But what if that branch is like, but what we think you're doing is constitutionally problematic? And then the final part of FDR that I think is interesting there is he also resorts to, and I think this becomes more familiar, even though he's articulating a vision saying, read the Constitution like you read the Bible, and articulating a vision against the court, he ultimately resorts to a kind of court packing, like how he's going to achieve his constitutional understandings is to put more justices on the court who will then follow his interpretation and understanding of the Constitution. And that, I think, in the end, leads to a much more legalized view of the Constitution, right? Which you see, you saw that in recent years, where if you don't like court opinions, rather than arguing with them and thinking about them and the duties before you, you're like, well, let's just put more justices on the court and we'll work through the courts. And that, I think, lends itself far more to a legalistic understanding, where you're kind of accepting a form of judicial supremacy. The court will decide things. You're just wanting to, put your justices on the court so that it'll be your understanding articulated by them that triumphs.
Right, and you talk a lot about the struggle over the Commerce Clause,
Yeah,
right? That
yeah,
the court seemed to put a brake on the National Industrial Recovery Act and on the Agricultural Adjustment Act, on all these things he wanted to do, FDR wanted to do for recovery and reform, and yet he eventually gets it, and we sort of have this governing through the Commerce Clause. Can you just briefly
yeah,
address
and
that?
that's and it and it's and it's interesting at the time too because uh, you know uh, some of the Commerce Clause cases where FDR is pushing national power are decided by the progressives on the court, where they're kind of skeptical of some of the national overreach. And so there's right, both with some of the figures on the court that think, but you are pushing national power maybe farther than it goes, and then in his own party even also is like, hey, you can't engage in packing the court, that seems to be problematic. So there's those Madisonian elements of the Constitution institutionally are still there, but the struggle over the Commerce Clause, um, it in the end, as FDR puts more justices on in time, really shapes out his way. And you have a kind of middle period where you get the court saying, okay, there's pretty robust national power, but it's still within a system of dual federalism, and there are limits, and the court has a constitutional obligation to police those limits, even while upholding subsequent New Deal legislation, which actually was changed and reformed based upon the court striking down some of the first rounds. But then you ultimately get with FDR's justices having a majority on the court, you ultimately get the court simply retreating from any notion that it would really engage in policing the limits of Congress's Commerce Clause power. And so you get a retreat saying that that's really something that will be settled totally by the political process, where the court by and large won't have a role in it. And that really kind of carries out through much of the second half of the 20th century, until I think you get Reagan playing FDR in some sense in reverse.
Right, and great segue into my one of my last questions here is that Reagan attempts to restore this Madisonian Constitution through originalism. Was he successful in achieving that?
I'd say yes and no. And Reagan is he's the first president since FDR to clearly embrace and articulate this understanding that the president and the Congresses and the other branches of government have a role in constitutional interpretation, and to reject clearly the idea of judicial supremacy, that the court is not just authoritative again in deciding the cases before it, right? The Madisonian understanding accepts that they resolve the cases. That's what they do. But again, do they resolve the broader constitutional question when it comes before another branch of government? And so Reagan's, the first president to really clearly articulate that since FDR. And then just kind of as a side, we should pause just to think that, Americans engage in this kind of ranking of presidents, and it's almost certainly not a coincidence that when we think of, post George Washington, the presidents that, make the ranking, they're all engaged in constitutional interpretation in their own right. They're all what under the Reagan era, and then today we would call departmentalist presidents or departmentalism, and that is the idea that each branch of government, in carrying out its own duties and the duties before it, each department gets to interpret the Constitution in its duties. That doesn't mean the other branches have to accept it, right? I mean, that's part of the clash. But so Reagan, I think, clearly brings that back. And that part is powerful. At the same time, the way Reagan, I think, achieves many of his outcomes in the end, because for him, he says, this should coincide with the jurisprudence of original intent. And right, that's the idea, at least for Reagan, that the court should be, or we should be, deciding constitutional questions based upon the intent of the founding generation. That subsequently gets refined, especially by Reagan's justices, to become what's now called original meaning originalism. And that's the idea that we should decide cases, we should decide constitutional meaning based upon how the people who ratified the Constitution understood it. And Reagan is absolutely successful insofar as he brings originalism out as a way we should think about the Constitution. And obviously, right, that's been become increasingly dominant to the degree to which you could argue that it's maybe the dominant mode of thinking about the Constitution these days, with some questions. And certainly on the contemporary court, you have a clear majority who's, and Chief Justice Roberts is sort of there, sort of not, who adhere to originalism in some way or another. So on at that level, Reagan was very successful. I think with some irony, at the same time, it's again much like FDR did. Most of Reagan's constitutional achievements in that way actually came through court decisions, and so there's a legalistic take to that, and originalism in those terms is I don't want to overstate it, because most originalist scholars would say they're departmentalists of some sort or another. Not all, but most. All the original jurists on not just the Supreme Court but elsewhere insist upon a kind of judicial supremacy, and I would say that's really become post-Reagan. That's been true of most presidents and most members of Congress, right? I mean, so when they engage in constitutional debate, they're kind of working through the courts and the court system and trying to achieve their constitutional goals by way of courts, and give primary deference to the courts on constitutional questions. And you see, liberals, progressives accept that too, and their solution was sort of court packing, right? So when you had constitutional conflicts, that's how they were going to sort them out.
Great. So my final question goes back to our guiding question, a very simple, straightforward question. So is the Supreme Court the final word on the meaning of the Constitution? And I say that tongue in cheek, of course. Right?
Yeah. I would say no. And I think we'd be better as a constitutional republic, a polity, if the political branches and the people attended more carefully and more thoughtfully to constitutional questions. And that would on occasion mean, on really serious issues, disputing the court's reading, and not just disputing it in newspapers and op-eds, but disputing it in terms of how the executive acts or how the legislature acts. Now, again, just to be exquisitely clear on the point, that doesn't mean not following court decisions, especially Supreme Court decisions, as they resolve the dispute to the parties to the case. Those should be viewed as binding. That's what courts do. They resolve legal disputes that sometimes are constitutional disputes. And so just maybe to go back to wrap it up, when the Supreme Court handed down the Dred Scott decision, the parties to the case have to go with that decision. So when Abraham Lincoln becomes president 4 years later, he doesn't get to go say, oh, no, Dred Scott is a free person, because that's how the court should have settled that question. He doesn't get to challenge the court in that way. How he gets to challenge the court is in the course of making its decision. Chief Justice Roger Taney also said, but blacks can't be citizens of the United States. And Lincoln says, I think you're wrong on that score. So when it comes to the State Department issuing passports to free blacks, can the president, can the State Department say, well, we think free blacks can in fact be citizens, and so we're not bound by the broader constitutional understanding of the Dred Scott decision, and so we're going to proceed to issue free blacks passports because we think they can in fact, contrary to Dred Scott, be citizens of the United States. And I think that's the kind of constitutional government, constitutional framework that's more comfortable with constitutional disputes and having these constitutional questions play out as part of constitutional politics, that's more in accord with the kind of constitutional self-government that Madison thought would be the central feature of our constitutional system.
Fantastic. George, I want to thank you very much for joining me on this very important and relevant topic.
Great. Thank you so much for having me. It was a pleasure.
And thank you all for joining us on this episode of Scholar Talks. Please check out the other episodes in our America 250 series.